Thank you, Mr. President. Nothing is more fundamental to our democracy than the right to vote. Last year, we celebrated the 50th anniversary of the Voting Rights Act, one of the most important pieces of legislation we passed in the 20th century. It opened the door to millions, literally millions of Americans to exercise their constitutional right. But this year will mark the first presidential election in a half century without the full protections guaranteed by the Voting Rights Act. 3 years ago this week, the Supreme Court gutted a key part of the law, taking the teeth out of provisions that protect voters from suppression laws with its decision in Shelby County versus Holder. Since that misguided decision, states across the country have passed new voting restrictions that would disenfranchise hundreds of thousands of Americans. And Ohio is ground zero, unfortunately, to those efforts to restrict voting rights. These laws passed by an ultra-conservative state legislature in Columbus include cutting early voting and eliminating the Golden Week, created by a more moderate Republican legislature of a decade earlier, the Golden Week when voters can register and vote on the same day. In other words, early voting starts a week before registration closes. So during that week, a new voter can register and vote in the same trip to the Board of Elections. This May, a federal court did the right thing, struck down that law, reinstated Golden Week and early voting, proving once again that these state legislators have gone too far. Judge Watson, a George Bush appointee to the Southern District in Ohio, found the laws limiting early voting and registration would disproportionately impact African Americans. Think about this. A decade ago, a more moderate Republican legislature passed the Golden Week, created the Golden Week, and passed pretty open voter registration laws. This very far-right legislature chipped away and rolled back and weakened these laws in a George Bush appointee to the court, apparently also more of a moderate, open-minded Republican that we saw 10 years ago in the legislature, reinstated much of what these legislators had done in the early 2000s. Then earlier this month, another Southern District judge, Judge Marbley, struck down another one of these restrictions. He ruled that Ohio's rollback of access to absentee and provisional balloting would also disproportionately disenfranchise African American voters. 2008, African American voters voted early in person at a rate more than 20 times greater than white voters. In many communities, it's what African American leaders and activists try to do, is encourage church members and people in the community to go in and vote early in person. Totally legal. It means that so often some people plan to vote on election day and then they either get sick or they have to stay longer at work and they lose that vote. That's why early voting is so important when people choose to. We remember the scenes from Cuyahoga County in 2004 when some voters waited as long as 7 hours to vote. I remember standing at Oberlin College where people had to wait 7 or 8 hours. At Kenyon College, students waited sometimes longer than that, 9, 10, 11 hours to vote. For hourly workers, for college students who work a third shift, for persons who have to drop their children off at school, early voting ensures that their vote will be heard. And maybe college students can stand in line a little longer because professors are pretty good about letting them, if they miss class because they were voting. But a parent who stops at the polling booth at 5:30 after work needs to vote quickly and pick up their child, has to stand in line for an hour and a half. They're maybe not likely going to vote in the end. That's why early voting is so important. 2012, 600,000 people voted early. That was 10% of the electorate. That's 600,000 voters' voices that might not have been heard if we hadn't had early voting. Ohio's law may have been struck down. Too many other states, though, have passed harsher laws that we know will keep voters, often voters of color, from the polls. 17 states have passed new voting restrictions since the Shelby County decision. It's almost like they're waiting for their Supreme Court, their very conservative, anti-voting rights Supreme Court, to make their move, and then they quickly, in their state legislatures, moved to restrict voting rights. In Texas, a new photo ID law is under court review. A federal judge called it an unconstitutional poll tax that could disenfranchise up to 600,000 mostly Black and Latino voters. In North Carolina, the legislature and the governor have gone even further with a whole package of restrictions, including ID laws, reductions in early voting, the elimination of same-day registration and voting. We're the only advanced democracy in the world where there are actually efforts to restrict access to the ballot box. We know who gets hurt the most. It's African Americans, it's seniors, it's young voters, it's Latinos. These restrictions were made possible primarily because the Shelby County decision undermined and gutted the Voting Rights Act. There is a solution. Congress could pass the Bipartisan Voting Rights Advancement Act today. We've done these with overwhelming votes in the past. Not that long ago, Congress almost unanimously reauthorized the Voting Rights Act not that many years ago, but then the court struck it down as if the court's wiser than an almost unanimous Congress. We could restore the full protections guaranteed by the Voting Rights Act. In 1981, when signing an extension to the Voting Rights Act, President Reagan called the right to vote the crown jewel of American liberties. This remains true today. Few rights more fundamental to our democracy than the right to vote. We must continue to do everything in our power to defend it. With elections at every level of government only 5 months away, it's more important than ever that we push to restore the most sacred of rights, the right to have a voice in our democracy.